Hi, my name is Erich Straub. I'm an immigration attorney with Straub Immigration, and this video is an update about the guidelines that the government issued on August 3rd, 2012 as they relate to deferred actions, specifically as they relate to crimes and a person's criminal record and how that would disqualify them from deferred action. We did an earlier video that talked more in detail about deferred action and who qualified for that and some of the risks and benefits of applying for that. If you don't know whether you're eligible for deferred action or you don't even know what deferred action is, I would encourage you to go back and look at that earlier video. This video is about a person's criminal record and how that record may disqualify them from deferred action. And so the government had, prior to August 3rd, 2012, already identified three distinct areas that could disqualify an individual. And that was if you had a single felony conviction, if you had a significant misdemeanor, or if you had three or more non-significant misdemeanors. Now, the three areas that the government has identified are what we call automatic or statutory disqualifiers for deferred action. There's also another concept in immigration law that everyone who's thinking about applying for this should be aware of, and that's discretion. And it's the idea that even though you may not fit into one of these automatic or statutory disqualifications, the government can still look at your whole record to decide whether they want to approve your application. And that's why it's very important for anyone who has had any contact with law enforcement to seek the advice and counsel of a competent immigration attorney before making the decision to file for deferred action. And that raises a really important point about this video, which is that this video is for informational purposes only. You do not, by watching this video, have an attorney-client relationship with Straub Immigration, because we would have to consider the specific facts and circumstances in your case in order to form that relationship with you and give you accurate legal advice. So let's go back to those automatic or statutory disqualifiers for deferred action. And the first one was a single felony conviction. And one of the important things that we learned from the guidelines being released is that the government is going to use the federal definition for what constitutes a felony, which is any offense punishable by imprisonment for a term exceeding 1 year, 365 days. So the second automatic or statutory disqualifier is a significant misdemeanor. And this is a term that prior to the guidelines, we really had no guidance on because it's a new term that was created specifically for deferred action. And again, the government is going to use the federal definition of what a misdemeanor is, which is an offense with a term of imprisonment that is greater than 5 days, but is not more than a year or 365 days. The government also narrowed the definition of what significant misdemeanor is. They've now stated that it can be a domestic violence offense, a crime of sexual abuse or exploitation, a burglary, unlawful possession or use of a firearm, drug distribution or trafficking, and drunk driving. A significant misdemeanor can also be any misdemeanor for which someone served a jail sentence of more than 90 days. So the third automatic or statutory disqualifier is three or more non-significant misdemeanors. And the government gave us additional guidance in that area as well. And probably the most important piece of information that they gave us was that a minor traffic offense, even if it is considered a crime in a particular state, is not going to be considered a misdemeanor. So I've talked about some of the automatic or statutory disqualifiers. And a little bit earlier we talked about discretion. So I want to talk about how discretion could be used to deny an application. One of the ways is if you are a gang member or you have been affiliated with a gang or participated in their criminal activities in the past. So another way that the government may exercise discretion to deny your case is a lengthy arrest record. So you may have avoided one of the automatic or statutory disqualifiers. But if you still have a lengthy arrest record, the government may deny your application. So another way that the government has identified that it may exercise discretion unfavorably is if you have an expunged record or a juvenile record. And so if conviction was expunged, or if you have a juvenile record, even though those may not disqualify you under the automatic or statutory provisions, they may be the basis of a denial of your application in the exercise of discretion. So to this point, we've talked about what kind of criminal activity may result in a denial of a deferred action application. Let's take just a few moments to talk about why it's important to seek out the counsel of a competent immigration attorney if you are in this situation. And one of those reasons is probably pretty obvious. The government has stated that their highest priority in terms of deportation and removal is for people who have felonies or serious misdemeanors. So folks who are in that category are at a very high risk for deportation and need to carefully consider whether they want to make an application. Another reason why you want to seek the advice of an attorney is even if you don't fall into one of those automatic or statutory disqualifiers, we've talked today about how the government can still use this concept of discretion and consider your entire record and potentially deny your case. An attorney may also be able to help you by pursuing what we call post-conviction relief. So even if you have an automatic or statutory disqualifier, or even if you have a bad arrest record or an expungement or a juvenile record that may be considered in the exercise of discretion, you may be able to go back to the prosecutor in that criminal case and then ask the judge to modify your record so that you are eligible for deferred action, or you may be more likely to have it granted. And then finally, anyone who is not a United States citizen, if they have criminal charges pending, should always seek the advice of an immigration attorney, because that is the stage at which an attorney can help you to the greatest impact in terms of avoiding a conviction or a record that may negatively affect you on the immigration side. At Straub Immigration, we have a reputation for achieving results in even the most difficult of cases. And whether your case turns out to be fairly straightforward or one of those difficult ones, I would welcome the opportunity to represent you.